and whether any individual, and there's no like smoking gun, there doesn't need to be a smoking gun under the federal bribery law, there just needs to be intent to be influenced. The jury needs to find beyond a reasonable doubt. So this is, look, I take no position on Senator Menendez's guilt or innocence. I bring my students to trial because it's a great show, example of what sort of modern federal bribery trials. And I take no position on whether, so I take no position on Menendez's guilt or innocence. But I do say that whether or not he is convicted, the idea that the way in which we are going to actually deal with the very real and present threat of corruption in our country is by having a very small number of federal bribery trials in which a jury is deciding what is in the heart of individual senators. This is not to say that there shouldn't be those prosecutions, but this is not a way to deal with the problems of corruption that we face. Even if he is acquitted, that doesn't mean that people aren't concerned about the fact that wealthy friends have more access than other friends to senators, that they aren't concerned about the problems of corruption in society. And they may not know, I don't know whether it was this senator or that senator or that senator, but I know on the whole, donors have too much power. And so the question is, why have we, so first of all, I'd argue that, yeah, we should have federal bribery laws, but the last 40 years we have relied far too heavily, and the Supreme Court in its own language has relied far too heavily on federal bribery laws to try to deal with very real problems of corruption. And I think the question is, why has there been this shift away from understanding that the prophylactic rule, the speed limit, is better than the Montana rule when it comes to facing corruption? I think there's a few different reasons. One is sort of an overblown sense of the role of prosecutors in fighting corruption. And I'm a big fan of, this isn't to say that they aren't doing really important work, but an overblown sense that they can somehow stand at the dike and put the finger in and stop the flood of corruption. I think the second reason is that, and I've argued this in my book, is that our Supreme Court is actually made up of people who have a relatively naive understanding of how politics actually works. These are not people who understand power, and they are often themselves people who come from an elite and doesn't necessarily want to accuse that same elite of behavior that seems normal. We're at a stage, I would argue, in American history, not unlike what Mark Twain called, the Gilded Age, where, and in the Gilded Age, the novel, which is great reading, by the way, what Twain talks about in a novelistic way is how there's a real split of language about what is corrupt between elites and everybody else. And he tells it through the story of Laura, the protagonist here, but she actually starts thinking of some things as corrupt and then no longer thinking of them as corrupt. And I think actually we have a society right now where there's a lot of behavior in Washington that most people think is corrupt, but people in Washington say, yeah, this is the way we do things. This is just normal, not unlike the end of the last 2 centuries ago. But actually, I think that the deepest reason for this shift relates to a lack of a sense of history. Perhaps we should all be reading Gibbon a little more closely. And a lack of a sense of the fundamental fragility of a self-representative society. That I don't know that Supreme Court justices are naive merely because they come from academic and appellate court backgrounds, but that there is an overwhelming sense almost that in Francis Fukuyama's much butchered phrase, and I may be part of that butchering now, that in the late 80s, after the fall of the wall, history ended, and we kind of figured out this democracy things, and there's some like problems at the edges, but it is not deeply, deeply fragile. Now, one of the things the framers understood is that democracies are deeply, deeply fragile. And that the job, I often think of the job of protecting self-government as a kind of whack-a-mole. The threats may come from different places at different times, but there's no steady state at which self-government is not under threat. It is constantly under threat. I think that sense of fragility, for some people in this country, not for all, but some people in this country really came to light in 2008 after the financial crisis. For other people, that sense of fragility they have only felt in the last, since the last election. But the fragility has always been there. And I would argue that we are always going to be ill-suited, even if we should bring bribery prosecutions, we are always going to be ill-suited to sort of discover in individual cases what is in somebody's heart. And so that we should instead really see the emoluments, foreign gifts, titles of nobility clause, and that kind of prophylactic rule. Or similarly, the prophylactic rule in the Constitution against holding office and being elected as the preferable way to deal with these very real threats of the fragility of self-government. Thank you for your time. I am happy to take questions. I imagine some of you are going to want to ask me questions about the litigation, and I should say in advance, probably because I was a litigator. I'm one of the lawyers on the Crew lawsuit, just so you know. Last time I litigated, I was a death penalty lawyer in North Carolina many years ago. And so I am, as I say every time I speak about this, I'm probably more cautious than other litigators, but I'm not going to be answering particular questions as applied to the litigation or hypotheticals related to litigation. But I am happy to answer questions about these sort of broad questions of different kinds of rules. All right, Andy. I saw the last 10 minutes of your presentation. You said, I guess I've been so persuasive that nobody has any questions. Thank you so much for having me.
Well,
I really appreciate it. I'm sure you're going to have fantastic questions.
Zephyr, you got to turn your audio on. Turn your audio back on. Here?
She's here.
Up here? Ah. Turn up your volume. Turn.
Oh, okay.
Hear us now?
I can now hear you. Yes.
Okay. Well, I'll ask the first question. Zephyr, how do you think the notion of quid pro quo plays into the discussion of bribery? Because the Supreme Court, I know you don't agree with it, but their jurisprudence is a bribe has to have a quid, a pro, and a quo, whereas a present or a gift is simply if it's property, there's no expectation of anything in return. So what's your position there?
Oh, Josh, thank you so much. This is one of my favorite topics.
I know it is. I know it is.
I have a real pet peeve here. Because quid pro quo, sounds like bribery law, right? So quid pro quo is not part of bribery law in any serious way until the 1970s. So I know, Andy, you don't like the counting. I don't like the, no percentages and numbers. But if you look at, I forget the exact number, but the phrase quid pro quo only shows up. I'm going to turn the volume down again right now just so I don't get that feedback. The phrase quid pro quo just does not show up in bribery law, including interpreting bribery statutes, really until the late 70s and early 80s. It's actually a phrase that comes from contract law. I'm not a Latin scholar, I'm sure those of you are, but as I understand, it means the relative equality of the exchange, not the fact of exchange. So the quid pro quo is about the relative equality of exchange. So the Supreme Court actually starts infects white-collar criminal cases and the Supreme Court's own usage of white-collar criminal cases. Now, my own hunch here is that it's a little rude, but I think that people feel like, if they're using a Latin phrase, it's like really solid and smart and has like really clear contours. So you say quid pro quo corruption, like that sounds like that has really clear lines. But as the Sixth Circuit quipped, again, in the white-collar criminal area, not all quids are made of the same stuff. In fact, there's a pretty substantial circuit all over the placeness about the nature of interpreting 18 U.S.C. 201, the Hobbs Act, and the mail and wire fraud statutes in terms of what precisely this phrase means. So it's had this very strange career, contract law to campaign finance law to federal bribery law. And so I think we just do better if we take the Latin out of it and have a real debate about what we think the terms of the statute mean. Because the statute itself doesn't include the word quid pro quo, it includes the word corruptly. There's so many different directions I could go with this, but what has happened is that in 1976, so Franklin was worried the Republic would only last 200 years, right? And then in 1976, Buckley versus Vallejo was decided. So I'm just saying. Okay, so I won't give a long answer. Anyway, mostly what I've talked about right today is white-collar criminal law as compared to the emoluments clause. But the other comparison is to campaign finance laws, which also provide absolute speed limits. Say, hey, you just can't spend more than X, you can't spend more than Y. And in 1976, the Supreme Court said, basically, you can't pass limits on campaign spending unless those limits serve an anti-corruption purpose, which suddenly put everybody on the hunt for what does corruption mean, because you needed to then say, either does this. In recent years, the Supreme Court has said, by anti-corruption purpose, we mean anti-quid pro quo purpose. And by quid pro quo, we mean, and even the Supreme Court isn't precise here, by the way. They use the phrase quid pro quo, but they mean something like an explicit exchange. And the degree of explicitness isn't entirely clear. You and I could have a much longer conversation about this, Josh, but I'll stop there. I guess what I would say for those in the audience is I think sometimes when you see Latin, you're like, I'm just gonna write it down. That's clear contours. But be wary of the fact that this effort to find certainty at the margins when you are applying the language of quid pro quo, that doesn't provide a certainty that the Supreme Court seems to think it does.
Okay. Are there any other questions? Anyone else? All right, I think we're 10-minute break now? Yes. We have a 10-minute break, everyone. Enjoy. We'll be back afterwards.
Yeah.